When I was 25, it didn't seem to me possible to have a life that integrated my sexual orientation. And when I was 30, it did.
In 1978, somehow there was that sense that the world was about to change, that there were opportunities to change, that people were willing to listen.
This demonstration happened, and for some reason we were not afraid. There was obviously energy, and there was more than a willingness, a real eagerness to change things. So we started GLAAD.
Our mission primarily was to allow gay people to speak in our own voices in the courts on matters of concern to us, and that just hadn't been done before.
We started winning, and that, that changes things.
Maureen was her parent. Any agency of the government, even medical, doctor's offices, medical people, anywhere we went, I was not the parent.
I remember getting maybe the citation to the adoption statute or something, and I remember going and reading it myself and thinking, it really doesn't say anything that prohibits us from adoption, so why not? And that's kind of what put the thought in my mind.
You had a couple who'd been together for a very long time, who'd been very thoughtful about bringing a child into their lives, where both parents were deeply involved in raising her. So it was just, a great window into what a good family can look like. And that was news to a lot of people.
Here we were, with this victory and this decision that was going to make this possible. We felt like we wanted to really try to help her understand that this would be something good for our family. She thought something great, like a present was coming or something, and we were all excited. And so when she realized there wasn't going to be something that concrete, she was like, okay, all right.
Dr. Bragdon was a dentist in Bangor, Maine, who had a written policy that he didn't treat any patient who was HIV positive. What Dr. Bragdon did was he really raised the specter of what if. And because there was so much fear around HIV, that specter had a lot of power. And so it shaped up for us as the perfect way to establish the law that that kind of policy violated the Americans with Disabilities Act. As much as we think it should be a no-brainer that people with HIV should be protected from discrimination, the reality is that that issue was decided in the United States Supreme Court by a 5-4 vote. And so our work is not only presenting the legal arguments, but presenting the clarity of a whole range of issues, whether it be the nature of HIV or the lives of lesbian and gay people, to the judges we're in front of.
We heard from a young student who said, I'm going to school and I'm being sent home.
The principal, he told me I couldn't wear skirts or just regular female clothing that any of the other girls could wear. He made me report into his office every morning before class to make sure what I was wearing was appropriate to him. For him to try to put a barrier up against me trying to better my life was, it was really hard for me.
It wasn't the first thing we thought of to file a case. We tried to negotiate, we tried to come up with some alternatives, and it really was just such an old world, old school experience to have him respond and say, absolutely not in my school.
He brought in the superintendent, and the superintendent said, well, if you don't like what we have to say, take it to court, sue us. So
that really ultimately led us to have to
do what they told me to do.
File a lawsuit in order to fix the problem that seemed to be going on. The courts were pretty swift and pretty clear in issuing opinions that said, this is not the student's problem. The school needs to fix its lack of understanding.
Once they said that, that our case won, or that, you know, it was always so relieving to me because, like, I knew that I wasn't doing anything wrong.
I thought it was really hopeful. It gave me the sense that not just Trina in her case, but other students across the Commonwealth could have a sense of empowerment, that they are deserving of respect in schools.
I felt like I opened a lot of doors for a lot of other people that are in my situation.
It mattered to me and to the folks here at GLAAD that we not simply wait to be on defense, but that we be on offense. Maureen and Ellen added so much to the case. I think the fact that their relationship had been so successful over these number of decades, and the same was true with Linda and Gloria, that they had decades of a relationship together, a successful relationship, just helped to speak volumes to other people. How would you feel if after 20 years somebody told you you were not eligible, worthy of marriage?
The day the case was presented to the SJC, we were all sitting together.
Mary Bonato's argument for the SJC was one of the most moving experiences of my life.
And we were all just sitting there basically stunned that, you know, she had delivered such a beautiful story of our lives and the case in 14 minutes, summarized, and she was done.
Historic and controversial day in Massachusetts.
Today in Massachusetts, for the first time in U.S. history, the civil marriage laws of a state do not exclude gays.
My favorite is the first paragraph. The Massachusetts Constitution affirms the dignity and equality of all individuals. It forbids the creation of second-class citizens. In reaching our conclusion, we have given full deference to the arguments made by the Commonwealth, but it has failed to identify any constitutionally adequate reason for denying civil marriage to same-sex couples. You know, my hair was on end. You know, I have to admit, it took me a while to read it because when I went to the court to physically obtain a copy of the opinion, I went outside and I was thumbing through it, trying to look somewhere in the middle to figure out what was the result. And I actually first went to the dissent, so I was terrified that we had lost. So it took me a while to be able to get to read that, but you know, my hair was on end, and I've talked to plenty of people who just wept reading those words.
The Supreme Court of Connecticut recently ruled that a separate status of civil unions for gay and lesbian couples cannot be tolerated under the Connecticut Constitution. One of the points that really comes out of a case in which you're litigating marriage in the context of an existing civil union law is that these cases are not just about equal benefits for same-sex couples. These cases are about equal citizenship for same-sex couples.
I love the idea that there are these principles in our state and federal constitutions about equality, and that as time goes on, people who were once seen as outsiders come to be seen as the full human beings and citizens that they are.
I think it's an exciting time because the transgender community has found a much more public voice. I think that there's more people who are able to come forward and say, I am transgender. And wherever that discrimination comes from, whether it's fear-based or difference-based, it shouldn't be sanctioned by the law.
People are now living long lives with HIV, and they're facing barriers because of that good news. I think that makes it even more important for GLAAD as a gay-identified organization to continue doing HIV work.
We've gone from being outsiders in the law to actually having the law on our side in a lot of respects.
GLAAD has redefined what's possible, and GLAAD has allowed us to imagine the lives that we want to live, and then given us the tools to be able to live those lives.